Good morning, everyone, and a very warm welcome to everyone that's joining us on this very cold morning. Thank you for taking the time to join us and to check that you're all signed up and attending the right webinar. This is, of course, about how we can make the internet safer for vulnerable people and considering the practical and legal considerations around that. Thank you for taking the time to connect with us. The list of attendees is very impressive, and it's clearly a topic of great interest to a wide range of people, professionals across the board, particularly as the internet now touches most of our lives, and we've learnt that particularly during this period of lockdown. So thank you, everybody. The purpose of this is to bring our clients, our communities and our colleagues together to discuss the live issues. This leads me on to introductions. Firstly, myself, my name is Katie Strong. I am a partner of Irwin Mitchell in the Court of Protection Department. I also act as a professional deputy on behalf of our clients in relation to their property and financial affairs. Next is Emma Earnshaw, who is a solicitor in our public law and human rights team, as is Rosie Banks. We also have Rochelle Mahapatra, who is a partner in our personal injury team. Moving on, we are also going to hear from Jeff Goodright, who is the director of Cyber Spider, and we have Nicola Swanborough joining us from the Epilepsy Society. We have very special guests with Claire Keir and Zach joining us. And I'm sure many of you have already heard of them and Zach's very admirable fundraising efforts during lockdown for the Epilepsy Society. Very sadly, that was targeted by online abusers, which is the subject that he is now focusing on to protect others from experiencing the same. So those are the attendees today who will be speaking to you. A little bit of housekeeping before we move on to our first speaker. Questions have already been submitted, and thank you to everybody that has taken the time to submit these questions in advance. You can submit additional questions throughout the session via the Q&A. That is a function on your screen that you should be able to see, and we're going to answer all questions at the end of the session. When submitting your sessions, please do include your name and your email address so that if we don't get round to answering your questions during this live session, we can respond directly to you after the event. We will be recording this event, and so this can be sent out to all attendees afterwards as well. Towards the end of the session, we'll be posting a feedback link, and we'd be very grateful if you could take 2 minutes of your time to give us some very valuable feedback. So this brings me on to introducing the first speakers today. Rosie Banks and Emma Earnshaw are going to speak to you about social media and legal guidance.
Thanks, Katie. So as Katie's explained, Emma and I are solicitors in our public law and human rights team. Emma is based in our Cambridge office and I'm based in Birmingham. We both specialise in court of protection and community care matters, often representing individuals or their family members in proceedings in the court of protection. Emma will be taking us through the fundamentals of the Mental Capacity Act framework, looking at the key principles of the Act, the test of mental capacity and decision making where it has been established that a person lacks mental capacity. She'll also be talking briefly about deprivation of liberty safeguards, or DOLS as they've come to be known. And I will then look at how the courts have approached the issue of capacity in the context of internet and social media usage, and what the practical impact might be once a conclusion has been reached that a person lacks capacity to make decisions about using the internet and social media. So I'll hand over to Emma first of all.
Thanks, Rosie. Yes, so I'm going to start by introducing the Mental Capacity Act and the overriding principles of that. If we could have the next couple of slides, yeah, and the slide after, please, Natasha. Thanks very much. This is a real sort of overview of section 1 of the Act, which outlines the key principles of the Act, which we will explore a bit further in a moment. I'll go through them quickly because they are important as if sort of underlying factors for the whole Act. The first one is that everybody is assumed to have capacity unless it's established that they lack it through the legal criteria. Nobody should be treated as being unable to make a decision unless steps have been taken to help them to make that decision themselves. A person is not to be treated as unable to make a decision just because he is making an unwise decision. That's a really important one, where somebody may be making a decision which you personally don't agree with, but ultimately that doesn't mean that they lack legal capacity. So the fourth one down is what we're largely going to focus on today, and that's when somebody has been determined to lack capacity, a decision needs to be made in their best interest, and there's various criteria which are factored into those sorts of decisions. And the final one is in relation to those best interest decisions, noting that any decision that's made should be the least restrictive option, so to promote that person's rights and freedoms as far as possible, whilst also keeping them safe. Next slide, please. Thanks. So this is a very basic sort of diagram which helps us to sort of visually see the decisions that need to be looked at when we're looking at a specific capacity question. So it's important to note that somebody can't lack capacity overall. There have to be specific decisions. So we'll come on to discussing a few of those, but it might be where that person's living, the care that they receive, the contact they have with other people, for example, just looking at that in isolation from everything else. So if there's no concerns and it looks like they have capacity to weigh up all the information, to understand it, to retain it and to communicate it, they can make their own decision, even if that's unwise. If it's more unclear whether they lack capacity for various different reasons, then their capacity should be assessed, and the outcome of that being if P does lack capacity, a decision would be made in their best interests. Again, if they have capacity, they should be supported to make that decision themselves, even if it appears unwise to other people. So I think on the next slide, we've outlined a few of the particular oh, sorry, before we go on to that, I'm rushing ahead. In terms of assessing capacity, this is what I was just talking about. So Rosie's going to talk in more detail about how the courts have looked specifically at using the internet and social media in terms of capacity. But this test is applicable to sort of all areas of capacity, and it's a statutory test for it, without the sort of nuances of specific case law that Rosie will discuss. So it's in sections 2 and 3 of the Mental Capacity Act if you want to have a look over it. Essentially, the first key point is that the person, the first key point is that it's time specific. So it's at that particular time that person lacks capacity. That doesn't mean that they will always lack capacity in that area or that they have always lacked capacity in that area. It just means at the moment they are deemed to lack capacity. There has to be an impairment of or a disturbance in the functioning of the mind or brain. So that may be a diagnosis such as dementia, for example, we see quite often, but it needs to be something that would create sort of an impairment in the functioning of a brain. A brain injury might be another example. So once you've established that that is in place, and again, it doesn't matter if it's permanent or temporary, if it's in place at that particular time that you're assessing, you need to look at the 4 criteria, which is whether the person can understand the information relevant to that specific decision, whether they can retain that information, whether they can use and weigh that information, and whether they can communicate that decision. And that's quite an important one, actually, because that doesn't have to be verbal communication. It can be via behaviours, it can be via sign language, it can even be via sort of pictures and Makaton, and you know, all the different various communication methods would count, as long as the assessor is certain that they can communicate in some form. So these aspects would all need to be looked at in terms of a capacity assessment, and if any one of them isn't present, so for example they are not able to retain that information, they would be deemed to lack capacity overall in that area, because they'd be deemed not to be able to make a decision. So I think it's the next slide where we've outlined some of those decisions that we may be looking at. So there can be disputes. Some of you may be aware of the Court of Protection, which is an area that Rosie and I work in. And if there are disputes over capacity or best interests between family members, local authority, and the person in the centre of this, then they may end up in the Court of Protection. So these are the things that we find come up quite frequently in our cases. So that's where and with whom they should reside, what care they receive, what contact they have with others, including sexual relations, marriage, divorce. They're sort of separate subcategories as well. Serious medical treatment, and whether they can consent to care arrangements which amount to a deprivation of liberty, which we'll go on to talk about. The key one in this list for today's purpose is obviously whether they should be able to use the internet and social media, and that's what would need to be looked at, following the test I've outlined, but also following the test that Rosie will outline, when you have a potentially vulnerable person who wants to access the internet. So again, just to clarify, if they're deemed to lack capacity in that area, then we would need to look at a best interest decision being made on their behalf. And next slide, please, Natasha. Great. So we've gone through what you should and shouldn't factor into the decision when you're looking at capacity. This slide focuses on what then the next step is, and what you shouldn't take into account when you're looking at best interests. So again, similar to capacity really, that you shouldn't be looking at the person's age or appearance, or aspects of behaviour that could lead to unjustified assumptions about what may be in his best interests. You should, however, be looking at whether the person might have capacity at some time in the future, so whether there's a possibility that he'll regain capacity, and if that does look likely, when that will be, and also it's not on the list is how they can be supported to get to that position, so maybe through like education sessions and things like that. So that's a basic overview about what we'd need to be looking at for best interest decision making, but obviously every decision is slightly different and there are different circumstances behind all of them, so there will be multiple factors that are sort of weighed up for that person. Next slide, please. These are the aspects in more detail about what a decision maker needs to look at when they're looking at best interests. So just to summarise these and pick out the important ones, I think a really important one is considering P's wishes and feelings, and that's certainly something the court thinks is really important if it gets to that stage. That should be factored in, even if you're saying that they lack capacity to understand the full decision and the full implications, they may still have a view about where they'd like to live, etc., which needs to be looked at. Similarly, considering the values and beliefs that they likely would have had and likely would have influenced that decision if they had capacity. So, you know, we've had cases where we've looked at their sort of cultural backgrounds, their families, religious beliefs, things like that. It doesn't have to be solely based on it, but it's one of the factors that you'd want to consider when you're looking at this. Again, the following sort of bubble there talks about factors that he would probably consider if they were able to do so. So that ties in with beliefs, values, culture. Taking into account the views of anyone else named by P, so that might be professional people, a deputy or something like that, or it might be parents, family members, etc. And the final one there, really important one, encourage P to participate as fully as possible. So, you know, with the caveat that they do lack capacity, but they still have very important views, and ultimately the decision is about them, so they should be participating in that. Next slide, please. Thanks, Natasha. So this is about the deprivation of liberty safeguards, which Rosie mentioned at the beginning. So I'm briefly going to talk about those to explain them a bit further. So these are, well, what they say on the tin really, in terms of being safeguards for vulnerable people who live in hospitals or care homes, or where they amount to deprivation of liberty, so where they're not free to leave and they are constantly supervised. This applies when they lack capacity to consent to the care or treatment they need. So, you know, if somebody has significant care needs, they lack capacity, perhaps they have dementia and they're living in a care home. Doesn't matter what age they are, it applies to all vulnerable adults. There are sort of new safeguards being processed at the moment, being looked at by the court. I think the bill's been approved, but it's not become law yet. So this is all subject to change. Although what with the current pandemic, it has been pushed back slightly. So we don't have a date for that yet, as far as I'm aware. The case that's listed below is the Cheshire West case, which you may have heard of. And within that, it outlines the acid test. So this is what's looked at to determine whether there is a deprivation of liberty. So as I say, it's if a person is subject to continuous supervision and control, and whether the person is free to leave or not. So if they're having 24-hour support in a placement with a locked door, for example, that would amount to a deprivation of liberty. Next slide, please. Great. So these are some more specific examples about that. As I say, movement subject to control, surveillance to ensure that P is safe, unable to do what they would want to do normally, i.e. can't sort of walk out the door, go to the shops, go and see family without support being in place and without staff knowing where they are. Generally being restricted in the choices that they are making. So the important point below this is looking at what can be classed as a deprivation, and it must be imputable to the state. So that means somewhere like a care home or hospital, or where they are receiving state-funded care. So if you're at home looking after a family member who is vulnerable and they are receiving 24-hour support, etc., but it's all private sort of family support, that a deprivation of liberty wouldn't apply in that circumstance. Next slide, please. So if P does reside in a care home or a hospital, that placement can monitor the authorisation themselves. Because you're depriving somebody of their liberty, it needs to be lawful, it needs to be authorised, and there need to be certain criteria that are met to show that the restrictions that are in place are proportionate to keep P safe in their best interests in terms of care arrangements. When a deprivation of liberty safeguard is put into place and authorised via a standard authorisation, they should be appointing an advocate to support a regular review of the DOL and to support P in representing any challenges they may have to the DOL. So, for example, Rosie and I deal with a lot of cases called Section 21A cases, because they fall under Section 21A of the Mental Capacity Act. Essentially, if somebody is in a placement and they are challenging that, they want to move home, they want to move somewhere else, they want to live in a different geographical area, that would be seen as a challenge to their deprivation of liberty, which they are more than entitled to bring under Article 5. Irrespective of the merits of that, which is an important point. So, you know, that can go to the Court of Protection, and they've got a right for that to be looked at and considered as to whether where they are and the care arrangements is the least restrictive option for them. If they're not in a care home or hospital, if they're at home, for example, but they have 24-hour support and they're not able to leave freely, meeting the acid test, then the local authority would need to make an application to the court to authorise that deprivation. And next slide, please, Natasha. Thanks. So just to summarise then, if somebody lacks capacity, decisions need to be made in their best interests. capacity is issue specific and time specific. And when we're looking at best interests following a determination that somebody lacks capacity, we need to be looking at wishes and feelings of the person and trying to encourage their participation as fully as possible in that decision. The local authorities and CCGs will often be the body coordinating decisions, and usually they would apply to the Court of Protection if there is a dispute about either capacity or best interests, and P would be entitled to their own legal representation in that, so that their views are heard throughout. So I think that's it for my part. I'm going to hand over to Rosie to explore a bit further into the internet and social media alongside capacity.
Thanks, Emma. Before I go on to look at social media and internet use, I can see we've had a question about how it's decided when a mental capacity test should be conducted. I'd say as a general rule, really any time a substantial decision needs to be made for a vulnerable person, for example, a significant change to their care package, or if there's some sort of proposal to restrict what a vulnerable person can or cannot do. And going back to what Emma's just taken us through, that's really on the basis that decisions can only be made for somebody if they have been assessed to lack mental capacity to make those decisions themselves. If not, the presumption is that they have capacity, and decisions on that basis cannot be taken for them. So hopefully that answers that question. I will now move on to looking at social media and internet use. Can I have the next slide, please? Thank you. So as we know, internet and social media networks are continually developing and have really changed the way that we engage with each other and with society. There are lots of positive implications of the internet and social media, and they can be particularly important for people with disabilities or communication problems. They enable people to create and access online communities from their own homes. They provide an opportunity for disabled users to exercise more autonomy, to learn new skills, develop careers, and express social identity. But there is also a much darker side to the internet, and we know that abuse via the internet occurs quite commonly and in various different forms: bullying, harassment, sexual abuse and grooming, amongst other issues. And the risk of being subject to abuse is of particular concern for children and those with learning disabilities who might struggle to understand those risks and potential consequences. And the slide here just lists some of the behaviours and risks associated with internet and social media usage. Next slide, please. Thank you. So Re-A and Re-B were two cases that came before the Court of Protection last year, in which the court considered the issue of capacity to use the internet and social media. Mr. Justice Cobb gave the judgment in both cases and considered, first of all, whether capacity to use the internet and social media should be considered as a separate domain in its own right, rather than being assessed as part of the wider issue of a person's care or contact. And secondly, what the relevant information should be for the purpose of assessing a person's capacity. Next slide, please. So I've just give an overview of the background facts. First of all, Mr. A from the Re-A case was a 21-year-old gay man with learning disability, low literacy level and poor communication skills. He lived in a supported living placement where he had extensive personal care support. He also received training from a college, and he had several part-time work placements. Next slide, please. Concerns were raised about Mr. A's use of the internet. He would share nude photos of himself online. When he wasn't being supervised, he'd search compulsively for pornography, including paedophilic images and extreme or illegal sexual activity. He wasn't able to read or understand warnings about content and safety, and that meant that he would essentially just click through to different websites and web pages via links based on the images that he could see. And although he'd had some education and training about safety in intimate relationships, it was felt that he was simply unable to understand the risks to him of the actions that he was taking. And there was a concern that whilst he himself would be vulnerable to abuse online, that he could also end up committing criminal acts himself. Next slide, please. Miss B in the Re B case was a woman in her 30s. She also had a learning disability as well as epilepsy and considerable social care needs. She lived with her parents, but she was considered to be somewhat socially isolated. She had some challenging behaviours and needed support when communicating with third parties. And she was described as being wedded to her mobile phone, contacting people via various social media channels and sending intimate photos of herself, as well as her personal details like her address, to strangers online. Miss E was really keen to be in a relationship, and she would invite people online to be her boyfriend. There had been various safeguarding concerns raised about her contact and conversations with men, and she'd formed some risky relationships, including with a convicted sex offender who she wanted to live with and to have a baby with. Next slide, please. I can't see if the slide has changed, but I'll carry on anyway. Thank you. So first of all, the court considered whether capacity in relation to internet and social media usage should be looked at as an issue in its own right, or whether it should form part of the assessment of capacity in relation to contact or care. Mr. Justice Cobb decided that this issue should be considered as a separate domain in its own right, and he gave some fairly extensive reasoning for that. He felt that using social media for the purposes of online contact is distinct from other forms of direct or indirect contact, and also from general issues surrounding the person's care. And importantly, that if it was swept up in the context of care or contact, it would lead to the inappropriate removal or reduction of personal autonomy in an area which is extremely important to those with disabilities. Next slide, please. He went on to explain his view that there are particular and unique characteristics of social media networking and internet use which distinguish it from other forms of contact and care. And some of those points are listed in this slide. For example, that there's significant scope for harassment, bullying, exposure to harmful content that might not be so readily apparent if contact was in person. He also ruled out assessing a person's capacity to use the internet and social media separately as two separate issues, saying that the internet and social media are inextricably linked, because the internet is the communication platform on which social media operates, and therefore it doesn't make sense to treat them as separate things. Next slide, please. So, having established that internet and social media should be looked at as a domain in their own right when assessing a person's mental capacity, the court then considered what the relevant information should be that P needs to be able to understand, retain and use and weigh in order to have capacity in respect of this issue. And Mr. Justice Cobb gave 6 points. 3 of them are set out in this slide and 3 in the next slide, which we'll look at in a moment. So just working through them, he felt that the information that P needs to be able to understand, retain and use and weigh include the fact that, first of all, information and images which you share on the internet or through social media could be shared more widely, including with people who you don't know, without you knowing or being able to stop it. Secondly, that it is possible to limit the sharing of personal information or images and videos by using privacy and location settings on some internet and social media sites. And Mr. Justice Cobb did explain that he doesn't envisage that the precise details or mechanisms of the privacy settings necessarily need to be understood, but that P should be capable of understanding that they exist and be able to decide with some support whether or not to apply them. The third point was that if you place material or images, including videos, on social media sites which are rude or offensive, or share those images, other people might be upset or offended. And the judge explained that he chose the words rude or offensive specifically because he felt that they may be easily understood by those with learning disabilities, as including not only insulting and abusive issues, but also sexually explicit, indecent or pornographic. Next slide, please. So fourthly, the fourth point that Mr. Justice Cobb felt P would need to be able to understand is that some people you meet or communicate with online who you don't otherwise know may not be who they say they are. Someone who calls himself a friend on social media may not actually be friendly. Fifthly, that some people you meet or communicate with on the internet or through social media who you don't otherwise know may pose a risk to you. They may lie to you or exploit or take advantage of you, sexually, financially, emotionally and or physically, and ultimately that they may want to cause you harm. And finally, that if you look at or share extremely rude or offensive images, messages or videos online, you may get into trouble with the police because you may have committed a crime. And the judge explained that this final point is not intended to represent a statement of the criminal law, but that it should reflect the importance which a capacitous person would understand of not searching for such material and steering away from it rather than investigating it further. Next slide, please. The court also looked at what might be irrelevant information, and here said the understanding that using the internet may have a psychologically harmful impact on the user. Mr. Justice Cobb acknowledged that it is widely known that the internet and social media can be addictive. It can develop distorted views and cause distress. But he took the view that many capacitous internet users either don't specifically consider this risk, or that if they do, they are indifferent to the risk, and therefore he didn't regard it as appropriate to include. Next slide, please. So I think there have been different reactions to the judgment that's been reached, and some suggestion that it might have set the test too high, and query whether all internet users do take all of those points into account when using the internet and social media. In general, though, the approach seems to have been broadly accepted. And I think it's a very good example of the difficult role that the Court of Protection has in trying to achieve a balance between essentially empowering vulnerable people by protecting their rights and freedoms and encouraging autonomy, versus the need to try to protect them from harm. Next slide, please. So once a person has been assessed to lack capacity to use the internet and social media, what happens then? Well, just going back to Emma's explanation of best interest decision making and restrictions on a protected party's liberty, the least restrictive option should always be taken. So this doesn't mean simply placing a blanket ban on somebody being able to have any access to the internet or social media altogether. Any arrangements or restrictions that are put in place should be very much on an individual basis, taking into account P's wishes, and they should also be proportionate to the risk of harm. And that was something that Mr. Justice Cobb underlined in the Re-B case, where he specifically said that any interference with those rights will have to be justified and proportionate, that careful thought will have to be given to the ways which can be devised, which are effective in limiting or supervising Miss B's internet and social media use without being unduly restrictive of her rights and freedom of action. In the Re-A case, the judge came on after assessing A as lacking capacity to make decisions about using the internet and social media to actually approve an internet access and safety care plan as being in A's best interests. And that care plan comprised various different measures, which included using an iPad for a limited period of time each day under a degree of supervision. A's phone contract was financially capped. His mobile phone had no capability to access the internet, and it was agreed with A that staff could check his phone for messages on a daily basis to support him to deal with unwanted text messages. I've just listed on this slide some more examples of measures that might be taken in individual cases. And the final one, education and feedback following incidents, I feel is probably the most important, because it really recognises the need to work with P to explain what the dangers are of using the internet and social media, to give P the best possible chance of understanding these. So if I could have the next slide, please. We've just included this slide out of interest, really, because it relates to a slightly different possible approach by the court, where information in this particular case, in fact, video footage of P had been uploaded online. So this was an application to the Court of Protection to consider whether a lasting power of attorney should be revoked. But within the proceedings, the local authority brought an application for the court to make an injunction to oblige a family member of P to take down some YouTube clips relating to P and to the Court of Protection proceedings. The judge did actually make the injunction in this case, but it seemed to be because the information related specifically to the Court of Protection proceedings, which went against an order prohibiting any information about the proceedings being publicised. The judge actually expressed doubt that ordinarily removing online information relating to a person who could not consent to it being uploaded would be a matter solely for the Court of Protection, and felt that actually a civil claim in those circumstances would have to be made, although that the Court of Protection might have a role to play in considering whether a claim of that nature was in P's best interests. Next slide, please. So just some final practical considerations for those of you who may be working with people with learning disabilities or communication difficulties who may want to access the internet. We've talked a little bit already about some of the restrictions that might be placed on P once a decision has been made that they lack capacity in this area. Before you get to that point, This slide just lists some points to consider. So working through those, it's a very good idea to keep an accurate record of any concerns that arise or issues relating to P's use of the internet and social media. It's also a very good idea to arrange training for P on how to use the internet safely and how to avoid the darker side of the web. And those 6 points set out in the judgment of Mr. Justice Cobb could very much be used as a starting point for training or education around the use of the internet. If there are concerns about P's use of the internet and concerns that P may be at risk or using the internet and social media in a way that might place them at risk in future, then capacity assessments can be completed using the guidance set out by Mr. Justice Cobb. And finally, any other concerns we've said here may require separate welfare proceedings should be flagged to the deputy. That's quite a general statement, but I suppose examples might include concerns about capacity evidence or any assessments that have been undertaken to date, or concerns about the restrictions that are in place and whether those are in P's best interests or the least restrictive option. And if there isn't a deputy, then it might be that concerns are raised with the social worker or simply the care provider in the first instance. So that brings us to the end of our presentation. As Katie's explained, we'll be taking questions at the end of this morning's session. So on that basis, I will hand back to Katie, who will introduce our next speaker.
Thank you very much, Rosie and Emma. That was very interesting talk, and I know that some questions have been answered as we've gone along. So thank you all for asking questions and using the Q&A function. Please keep doing so, and I know that some of those questions have been addressed as the presentation went on. So next is for Jeff Goodright of Cyberspider to present to you, and this is giving you practical advice on using the internet as safely as possible, and focusing on those sites that may cause the more concerning content. I know that he does offer that bespoke training that Rosie was just referencing, so over to Jeff with my thanks.
Thank you ever so much. Can you see the screen okay? Has it come up?
It certainly has, yeah.
Excellent. That's what I like to hear. Yeah, well, it's quite good timing actually putting me on after the last two speakers, because it sets the scene quite well. And it was interesting as well listening to the judge's thoughts around the internet, because one of the big problems, and this is not a criticism of the judge, I wouldn't be that bold critical of a judge, but certainly the big problem we face is that as individuals, the majority of us don't understand what the internet actually is. We don't understand its relationship with the web and social media and the other different aspects of the internet. In effect, the internet is just a medium that we access the other areas. So I don't want to digress away from the purpose of the talk. It's food for thought, really. But if we, the legal system and those that support those with vulnerabilities, if we don't fully understand the cyber world, the digital world that's out there, how can we make decisions on their behalf as to what's actually good for them? But anyway, that's digressing a little bit. So the purpose of the session this morning really is looking at vulnerabilities in the cyber world and asking the question, what do you look like in the cyber world as an individual? And carry that question across to those that you've got responsibilities for. So safety is what we're about really at the end of the day. So you as individuals, what do you look like in the cyber world? What does your digital profile actually look like? I know quite a few people will Google themselves and look at the results, but how often do we actually spend a bit of time looking at what we look like? So what do you look like as an individual? How easy are you to find on Facebook or other social media? What do you look like professionally? For quite a few years now, companies are doing research on students and those that are applying for jobs. HR are doing this process to find out whether the person you're portraying in your CV is actually the person you're getting, and that's obviously found through social media and other sites. What about your family as well? How safe and secure are your family? You might have quite a tight set of settings on your internet usage, but actually it might be your family that are the weak spot. And if you've got responsibility for your clients, if you're a court protection deputy, or if you've got responsibility as a case manager or support worker, what do they actually look like online? How secure are they and how safe are they? Now, I don't want this session to be a big advert for CyberSpider, but obviously CyberSpider's featuring on quite a few of the slides that you're going to see. So just ever so quickly, give you a little bit of background. Myself, Jeff Goodright and Gary, both retired police officers. I know we don't look old enough. There's a story behind it, but we retired from the police and we set up CyberSpider a couple of years ago with the intention of providing services for those that are vulnerable and those that are looking after people that are vulnerable around cyber security and cyber vulnerabilities. It's more about the vulnerability aspect that we try and address. So common problems that we encounter. We generally get phone calls from case managers or contact from deputies or families after something's gone wrong, which is obviously not a good time. Ideally, we would be involved before things go wrong to try and prevent them from going wrong, or to minimise the impact on the individuals by reducing the effect of it going wrong. Common problems that we encounter: social media, clients either making mistakes and saying too much, or getting involved with individuals on social media through spats, fights, that kind of thing, that then leads to real world issues where these people are turning up at addresses and physically threatening incidents. In-game chat as well. Now again, social media is quite a broad subject. So would social media include gaming apps? To some degree, I think they should be considered, because a lot of the gaming apps now include in-game chat and the ability to socialise with strangers through simple children's games, in effect, that are being played by adults alike. We've got dating sites, and I know mention was made of dating sites within the realm of social media and the ability to meet others. And many social media platforms actually fall under the umbrella of dating sites and vice versa. And again, as has been previously mentioned, inappropriate messaging and image sharing, which aren't unique to people that are vulnerable. Many adults out there are sending inappropriate messages and image sharing. So one thing I would say is start thinking about your social media profiles. Again, if you've got responsibilities for someone that is young and is looking at developing a social media profile, now is the time to actually start planning it and thinking about it. There's quite a few sites there. For example, I mentioned Facebook a lot because it is the biggest in the world as far as social media is concerned. We've got LinkedIn, Quiz, which is a quiz gaming site, but again is a social media site. Among Us is featuring more and more now in contacts that we're having from clients. That's a game. Twitter, WhatsApp, and so it goes on. So there are lots of profiles out there, and I'll mention in a bit more detail about setting your profiles up. But certainly if you've got those responsibilities and you haven't set the accounts up yet, plan it carefully. Think about, for example, the username that you're going to use, the photographs that you're going to use on social media sites, the email addresses, and I'd recommend you all have several email addresses. Don't just have one email address for personal use. So I talk about I mentioned in-game chat. But before I forget as well, Natasha, if you can hear me and you're listening, give me 10 minutes warning, won't you, before the end of the session, because I do have a tendency to rabbit off on and go off in different tangents. So in-game chat, is a feature in many children's games now where they can chat with their friends. So this one, for example, is Among Us, and the idea behind it is that I think it's 10 players in a room. One of the players is a killer, and the other players have to try and guess who the killer is. And the chat can take place to try and determine which one of them is the baddie. And it's it's addictive. Not that I'm playing it myself. I'm smiling because my son's playing it quite a lot at the moment. It is addictive, as a lot of these games are. And the chat that takes place is generally, in the main, children chatting about who the bad player might be. But you can see the opportunity here for offenders, for adults that might want to get into children's circles and start befriending children, can take place in apps like this. And I'm not saying it's happening in Among Us. There are lots of apps that have the same features, but that's inevitably where adults that might want to talk to children will end up. The difficulty is a lot of parents and those that have responsibility for those with vulnerabilities don't fully understand the apps and the capabilities of the apps. And that's why it's really important that you research the apps that you're putting on the devices. There's lots of age rating schemes out there. Apple has one. There's PEGI, P-E-G-I, which can be a little bit misleading when you see the PEGI numbers, because you might associate them with ages, which they're not necessarily. So understanding the age ratings of the apps that are being downloaded onto the devices can be an issue as well. And we do provide training around that side of it. Well, we will be doing very shortly. I'll mention that at the end. So research the apps that you're putting onto the devices. And I suppose this is another question that goes back to the court of protection, is if you're saying that an individual lacks capacity to use the internet or to use social media, does that extend to games? Are games considered? Certainly dating sites are considered within that, but games as well. So on the one hand, we're saying that somebody might not have capacity to use the internet, when in fact they might have capacity to use a gaming app like this that would allow social activities to take place. Again, I don't want to go off on a tangent with the discussion around this, but better understanding across the board, not just with those that are working with those with vulnerabilities, but right up through to the courts. Better understanding of the devices that are available, the capabilities of the devices, the software that's available to manage and protect on those devices, the software that's going to be used, the type of software that's being used, and not necessarily just your dating apps and your stereotypical sort of social media apps as well. So I think with better understanding of all the technology that's out there and the software that's available, more bespoke decisions could be made to individuals that would allow them to maximise what the internet can offer in terms of access to these different features and tools, whilst keeping them safe at the same time. And again, as was mentioned previously, there are certain steps that you can take, simple steps that will reduce your exposure to bad places, shall we say, on the internet. So one of the other areas, as I mentioned, that we get issues around is online dating. There are lots of online dating sites out there. Some dating sites appear to be more for social connections, very loosely speaking, shall we say, rather than actual physical dating, finding the love of your life and moving on and marrying. Interestingly, statistics and figures indicate that by, I think it's within 5 years, we will be meeting and forming relationships more through online use than offline. At the moment, we still meet people externally, meet people not so much at pubs these days, obviously with lockdown, etc. But actual physical real world dating is still in the lead, but it is being caught up rapidly by online dating, and that will take over certainly that initial introduction phase. Some of the problems we've had with online dating sites with clients is obviously linked to sex. The clients want to have sexual relationships, so they go online and start using dating sites, as do people without vulnerabilities. And so finding the right site for the client or for yourselves to go on, again, takes research. There are certain undertones and how can we say, it's almost a different culture on different sites. So if you were wanting to find love, then you might well go to a site like match.com. If you were wanting to find a physical kind of relationship without the love, then you might find something like Badoo or Plenty of Fish might meet that need a bit easier, or Tinder and others besides. So actually researching the website itself, finding out what it offers, finding out how it actually works, the costs that are involved as well, because a lot of sites will advertise as being free, when actually there's quite a significant cost to use it properly. And by using it properly and paying that significant cost, you can actually make yourself more safe, because it allows you to search and accept messages off certain people and so on. So again, it comes down to researching. So just to say that an individual doesn't have capacity to use online dating, I would say that there are lots that you can do, lots of things that you can do to find the right dating site to suit the client's needs, with certain features and protections around it. So again, it's quite a discussion to be had, and would need research according to the client's needs. The problem is, and again, as we're finding with clients, lots of this is happening, and this isn't just happening to clients with vulnerabilities. So this was a screen extract from a client, where this lady was sending photographs to the client through a messaging platform after speaking on a dating site, talking about birthdays and needing cash to celebrate. At one point, they sent this screenshot saying that I want to send you more photographs and chat to you, but unfortunately the camera won't work unless you send me an iTunes gift card. So obviously the male that was involved in this communication was wanting to see more photographs of the lady, and was wanting to be able to send iTunes gift cards to be able to see those pictures. It's a load of rubbish, and we were able to show the client that it's a load of rubbish, because the actual photographs being used, we found them online on numerous porn sites, and so the person behind that actual account had found images through porn sites and then used them as profile pictures and to send us pictures to try and tempt the client into parting with hard-earned money, to actually receive more pictures. There's lots you can do around photographs online to check to identify the whether or not the pictures are genuine or not, which takes us on to pictures and sharing of images. Again, as has been mentioned in the previous session, sharing of images, pictures, is a big problem. People do it. What I would say is, as far as images are concerned, one of the big points actually is halfway down, metadata. If you think of a photograph, a digital photograph, as being like a postcard. So if you were to send a postcard from yourself to another person, they would see the image on the front, but on the back of the postcard, you've got all the information about the address, where it's come from, any message you might have put in there as well. And that's very similar for digital pictures that you send and post online. They're like a postcard. You can see the image at the front, but behind it, you've got all the information, the metadata, about what device took the image, what camera it was, the settings of the camera that took the image, location, time and date information, name of the device. It might, let's say it's Jeff's mobile phone. It could well have that metadata in there. And the location information is one that people very often forget. If your location settings on your phone are being shared with the camera on your phone, the app on your phone that uses a camera, then it could extract your location information and share that on the images that are being sent out there. So awareness and knowledge around the devices that are being used and the settings on the device that are being used, really important. But what do you want to show? Do you want to show yourself? Are you going to show photographs that include photographs behind you on the shelves? It's great with Zoom at the moment on the national television. You see all these people being interviewed and they've got the bookcases on full display, and then you've got photographs of the family on there as well. And how much do you want to actually share nationally or personally with others. So things like pets as well, and family pictures. I mentioned a family picture, sorry, but pets. If you're looking to target an individual and find out where they are, and they've got pets photographs on their profile, then obviously they're going to be walking the pets at certain times of day. So if you can narrow them down to a particular area, a village, let's say, there might be limited dog walking locations where that person might go. So if you're looking for the pet and you've got an unusual pet dog, let's say, then it might not be too hard to find you and find where you're walking the dog at a particular time of day that might leave you exposed to physical threats. So there's a lot more that we can do in planning and preparing how we're going to share images, who we're going to share them with, and what image we want to portray in those pictures. And likewise, when you're selecting images for online profiles as well, people will use the same image, the same profile name on numerous different sites. So you can search on those usernames. There's lots you can do online in terms of searching for usernames and email addresses, etc. So if you're using a username of, let's say, Billy123, and you've got a profile picture, then, and you're on one site, let's say a dating site, and you're looking for lust, but then you're using the same username and photograph on another site that's looking for love, then the person can actually be compared and actually all the data can be taken from those two sites and put together, and that might give you more information about who Billy actually is, if that makes sense. We had one individual that was looking at for training purposes who was on Tinder using a profile picture, and it was quite clear from what was being disclosed on Tinder that this individual would like to meet members of the opposite sex for physical activities. When I did a search on that image that was being used, I found the same profile image being used on numerous dating sites, and in those dating sites there were pictures of families being shared and children and that kind of thing. So it's very easy to get a big rounded picture of that individual by picking out little snippets along them lines. And that's why I say it's really important when you're setting up profiles for the first time, especially for clients and vulnerable people, children, that you take your time and think about how you're going to make that individual look online and how that's going to be connected to other accounts. So profiles are what we sort of focus on. They're a big part of what we look at when we're doing assessments for clients around vulnerabilities. So I would ask yourself, really, how many profiles do you have as an individual? Have you got a Facebook profile? Have you got a LinkedIn profile? Do you have a company profile that's got lots of information and photographs on there? And what does that actually display and say about you, your family, your vulnerabilities? In most cases, your profiles are public facing, but who else is seeing it? Who else is looking at it? I'm more than aware that children, for example, will do open source research. They'll stalk teachers on Facebook and Google and so on to try and find information out about them, not in a malicious way, just that nosy side of us humans. And I'm sure you've all done it yourselves, done a little bit of Facebook stalking to find out about maybe clients, customers, other individuals that you might be working with, find out what other people in the office are up to, and so on. It's not hard to find information out about people online. So the question is, what profiles are out there that you've created, and what information is out there about you that you maybe don't want to be out there about you anymore? What we found with clients as well is that the persona and the profiles that they set up for public facing isn't a true reflection of them as an individual. We've had people putting on far too much information about themselves and not disclosing the vulnerabilities in any way, and perhaps giving the impression that there's somebody that they're not actually truly representing themselves as. So who's got responsibility for that? You know, actually setting up and helping them to set up their accounts as well. So think about your public facing profiles. Think about what you want to tell the public that will be looking at that profile versus what you're actually telling them at present. So just moving on a bit, then we've got devices. Devices feature quite a lot in the work that we do. because again, devices tend to get bought in a well-meaning way for people with vulnerabilities without thinking through how they're going to actually use them and what they need them for, and how those needs might change with time. So just recently, for example, we've bought for a client a basic mobile phone that doesn't connect to the internet, and an iPad that does connect to the internet, obviously, and we've set that up for that client's needs. Prior to that, they just had an expensive laptop bought for them through the case management system, but it wasn't appropriate. It wasn't the right piece of kit for them to have. But it wasn't bought, obviously, maliciously. It was just bought without the full facts of what might suit the client's needs. So the devices that are out there, and I would ask you to think about yourselves as individuals now. What do you know about the devices that you currently own? Do you have smart cameras? Do you have smartphones? Smart devices like the gaming stations, your mobile tablets that you can carry around, smart fridges, smart televisions, Ring doorbells, etc. But how well do you actually understand them? How well do you understand the security on them? How well have you actually set them up for use in a security conscious way? And if you think about the difficulties for us as individuals in doing that, what chance do those that we have responsibility for have of setting them up safely and securely? So understanding the devices is really important. Recognizing what the devices are is important, especially routers as well in properties. Who's going to use them and for what purpose is a question that we need to ask. And how are we going to connect it to the internet? As I've said, the internet is the highway. If you think of the internet as being the road network that covers the globe, that allows data to get from A to B. And data is what we generate when we send text messages, photographs, when we access websites. We send it around the internet. And there are two main ways of doing that. One is through using Wi-Fi, which is through your router or free Wi-Fi that's out and about. Don't use free Wi-Fi unless you really need to. That's a whole other talk on free Wi-Fi. So Wi-Fi is one way of connecting to the internet, and the other is mobile devices like your phones with SIM cards in, and using them as maybe hotspots as well, for example, or tethering. So we've got different ways to connect to the internet, but how secure are they? Are they set up correctly? A filter's been applied. Websites that you don't want to be visited can be blocked using router settings and other software. What sort of knowledge do you have as individuals of the internet and of the devices and the services that you use? How many of you watching now are on Facebook? And when did you last check your Facebook settings? When did you last change your passwords on the accounts? Do you use the same password on every account that you've got, along with the same email address on every account that you've got? So listing services, understanding the services that are out there that you use, or that your clients use, or that they want to use, again, is really important. It comes down to time. With one of the other sessions that we do around internet safety, we talk about the probability, the magnitude, and the cost of managing these threats. So what's the probability that something bad's going to happen to you? What's the impact going to be on you if it does happen? And what's the cost of preventing it or mitigating the effects if it happens? So for example, a mobile phone, what's the probability you're going to lose your mobile phone, or it's going to break or get damaged and not work anymore? You might think it's going to be low, unless you're a daughter who likes to shove the mobile phone in her back pocket and then forget about it when she goes to the toilet, and it pops out and slips down the toilet. And I'm sure that's happened to some of you listening today, and she'll thank me for sharing that story as well. But the point is, once it's gone down the toilet and it's broken, where do you go then? What's the impact on you? When did you last back it up? Do you have a copy of all your contacts? You might have cloud storage with a backup copy of it, but do you have insurance for the phone that covers you to get another new phone? Or are you going to have to fork out hundreds of pounds on a new device in order to start using it again? So actually working through the things that can go wrong and the impact on you can be a useful exercise, not just in physical devices, but on social media, on your banking, Instagram, Twitter, and so on. So going back to what I said about email addresses, usernames, very often people will use the same username, the same email address as the login, and the same password. And the problem is, once your details are out there and they've been compromised, and I'll show you how one way that you can check that in a minute, those keys, if you like, are out there for other people to use to get into your accounts. When you're setting up an email address, do you use your name or your nickname or your username? Is that easy to mimic or to guess or copy? And likewise, passwords. Very often we will use passwords that are linked to what can be found on social media. Pets' names, children's names, dates of birth of your children, that kind of thing, are all out there. What I would advocate, and it's worth considering, that there are lots of password management tools that are available online. So if you forget your passwords easily, there are password management tools and features that you can get, like on the Apple devices, where they will store the password for you and you use biometrics to open it up, or you just have one single password to access the passwords, fingerprints, facial recognition, for example. What I would say though is, why not write them down in a little red book or black book in your house? Write down the account, Facebook. I wouldn't write down Facebook username, password underneath it, just in case a burglar does break in and find a book and take it. But you could have your own system of recording usernames and passwords in that book. For example, if it's let's say it's an account number, you could put 07 before it and then add some random numbers at the end of it that make it look like a mobile telephone number. But you know that if you take the 07 off, you're straight into your account number, or PIN numbers, and put 07 in front of it. However you want to work it, whatever pattern you want to use. But record it, write it down, because the burglar's more likely to break into your home and take your TVs, your PlayStations, your phones, your money, your cars, etc. They're not going to spend time rummaging through a bookcase to try and find a book, or a little table with a drawer in it somewhere with a book with your passwords in. So consider that. You know, I wouldn't say it's a bad thing to write down your passwords and usernames. Just don't make it obvious what they are when you write them down. So I've mentioned email addresses. How am I doing for time, Natasha?
Just over 10 minutes left.
Brilliant, good stuff. So what I would say is, check your email addresses. When we finish this session, have a look at a site called Have I Been Pwned, PWNED. Type in your email address that you use. What you want is for it to come back green. If it comes back red, then you've got problems. Not big problems. So you type your email address in, press enter, and it'll do a search on databases that have been found online to have been breached, where a database breach has taken place. So in this screenshot here, for example, it shows that the email address that I put into it was breached through a Dropbox leak in 2012, where data breach was put onto the internet. This spam bot in August 2017 was a big one. 711 million email addresses were leaked. And the bottom one, Zynga, is Words with Friends, which is just a Scrabble game. They had a data breach. And in that data breach, they lost their customers' email addresses, passwords, phone numbers, and usernames. I did one yesterday during a training session, and the guy whose email address I checked was on about 8 sites and included physical home addresses, dates of birth, children's names as well. Some of them were children's games that had been compromised. It's quite scary. What I would say is, if you do a search on your email address and it comes back as red, first and foremost, if you use that email address on any current social media, banking, or other accounts where you might have some financial implications, go and change your email, go and change your password straight away, and create new email addresses. I've got an old email address that was breached many years ago, and I just use it for rubbish now. So if I'm perhaps registering to book a hotel, let's say, and then, or if I'm buying something in a shop and they want to send you the receipt through the emails, I give them that old email address because I'm not worried about that. So think about your email addresses, check your email addresses. Make a list, you know, work through the email addresses that you use, check them, create some new ones. When you create an email address, don't use your name, obviously. Use aliases. Pick your favourite characters out of a film or whatever it might be. Start using new passwords, and don't forget to use characters and numbers as well as words. You can use phrases. Jack and Jill went up the hill, that kind of thing, although I wouldn't use that as a password because I'm sure somebody has, and it's probably one of the most common ones now. But use a phrase that you can remember and throw in some numbers and different characters on that. There's some really good websites out there. As far as the national cybercrime, cybersecurity is concerned, the NCSC at gov.uk, there's some really good tips there for staying secure online. And likewise, the NSPCC have some good tips, and many others besides. So explore what's out there in terms of cybersecurity. One of the things we do, and this is a sales pitch, but it's not a sales pitch, it's a 50-50 if you like that. I'm going to try and balance. The difficulties you've got out there, certainly in the case management world, is there aren't many places you can go, and I believe we're the only company offering this at the moment. I'm still pretty confident that we are, but I might be proved wrong. There aren't many places you can go to speak to somebody to say, look, these are the problems that we're having or we foresee. What can we do about it? So one of the things that we do and that we offer for clients, we've been doing this for a couple of years now, is we can do a vulnerability search, a vulnerability check on someone. So it's obviously with their consent. There's a particular form that we complete, and you'll complete if you're requesting it. And we can do an online search for that individual to identify anything that jumps out in the headings that you can see there. So extremist groups, swearing and profanity, any negative sentiment, hate speech, violent images, pornographic images, any indications of compulsive behaviour or disinhibited behaviour as well. And where behaviour is found under those headings, then we include that in the report, obviously, to show you where to find it. So in this example that we did, you can see that the individual was using swear words, and we've actually got the Facebook account that links. The link takes you direct to that post with the language in it. So that can then be removed or remedied in whatever way, or left if you're happy for it to be left there. And it produces a certificate, a digital risk certificate that is, I suppose, reassures you, if you've got responsibilities for an individual, that at least at that time and date, that's what was present on the internet and that's what you did about it. We can do a deeper version of that as well, where we might be able to identify similar accounts that are being used, or cloned accounts, not cloned accounts, but duplicate accounts set up in different names but linked to the same individual. And we can also provide advice and guidance around what might be best for that individual, or what opportunities might be able to be put into place to secure the internet connection, website blocking, time and screen time monitoring, and screen time protocols, if you like, that can be put into place. We can also advise as well, and I'd strongly recommend, if you've got responsibilities for vulnerable people, make sure you've considered recording your decision-making processes around that, along with a policy, and having a policy in place for that individual. So if you're going to introduce things like screen time or monitoring of apps, monitoring of communications, make sure you've got a clear policy in place bespoke to that individual about who's going to monitor the messages that are being sent on the phone. Are you going to monitor the children's apps as well, and the messaging features within the apps, if they've got messaging features? So it needs to be specific about what is being used on that device, and a clear record of that decision-making process as well should be kept. And I'm hoping the solicitors would agree with us on that one. So as far as what we're trying to do as a business and as individuals with the people that we work with, it is just about getting people better educated for those that are in the position of responsibility, but also helping them to educate those that need that support. The internet is not a bad thing. You know, the web that is out there is not a bad thing. There's lots of bad things on it, but it's how you use it. And there are so many opportunities for these vulnerable people that we're trying to protect and help, for them to develop themselves and move themselves further on. and not just to be kept down all the time. So explore those opportunities, explore the apps. I've recently, yesterday actually, just purchased a virtual reality headset, and it's absolutely mind-blowing what you can do on it, and the world that it opens up, the virtual reality world. But the features with a handset, for example, that you can use, and the dexterity and the physical exercise that can take place in this virtual world, we're only beginning really to explore the technologies that might benefit those that we've got responsibilities for, be them vulnerable or not. So look out, coming soon to a good website near you, the Cyber Spider website. We're currently developing training, online training courses for case managers around cyber vulnerabilities for clients, recognising them and what you can do about them. It's going to include dating sites, in-game chat, social media, and setting up accounts and profiles will be on there. We're trying to aim it at a level that is easy for anybody to do. It's not going to be training that's for your cyber geeks amongst you. It's going to show you in layman's terms things that you can do with your router, for example, or for the routers of those that you've got responsibilities for. They're going to be short and sharp, so they're not going to be hours and hours. It's going to be a half-hour session on this, 40-minute session on that, so you can do it in bite-sized chunks. And as ever, you can contact us through the website. We don't charge for a conversation. If we can put things right or help you to put things right by a simple phone call, we'll do it. You know, yes, we're a business and we need to make a living from it, but by the same token, we're not in the business of ripping people off either. So if we can give free advice, we will give free advice to help you stay safe online. I'm aware that there's been some questions posted, so I'll hopefully help address those in the question and answer session that we've got coming up. So thank you. Our details are on the slides, but they're also there as well. If you've got a client, if you've got clients that you've got responsibility for, who you anticipate you might have issues with from a cyber point of view, or you've got ongoing issues, give us a call. Let's see if we can help you. But don't be afraid of the internet or what's on it. Explore it and use it. Just do it carefully. Thank you.
Thank you very much for that, Jeff. Very interesting practical advice. And as he's recognised, there is a lot of questions that's been generated by his talk. So we will be coming back to Jeff with some questions for some answers later on. We're going to take a 5-minute break now. The plan is to be back at 11:30. So do please have a comfort break and join us at 11:30 for Zach's Law. Thank you, everyone.
Well, welcome back, everybody, and thank you very much, Jeff, for that interesting and informative talk about cybersecurity. And I'm sure lots of you have got questions to ask him. We will be doing some questioning at the end for all the speakers, so if you'd like to put them into the Q&A section, then we will pick them up. And if we can't pick them up today, then we will obviously send out answers later by email. For those who don't know me, I'm Rachel Mahapatra. I'm the Regional Managing Partner of the Leeds office of Owen Mitchell. I'm also a clinical negligence solicitor, and I'm really pleased to introduce the next two speakers, who are Claire and her son, Zach. Zach is actually a client of mine. He suffered a hypoxic brain injury at birth, and he suffers from cerebral palsy, but he also suffers from severe epilepsy. And that's the reason why he has been involved with Zach's Law. During the first lockdown, Zach decided to do something to try to raise awareness about epilepsy, and he decided, inspired by Captain Tom, to do a walk. He has quite poor mobility, and so over a period of about a month, he walked in his back yard and did laps every day. He raised over £20,000 for the Epilepsy Society, and there was a lot of activity on social media about his walk. What happened next was quite shocking to me, because I didn't know it actually happened so much. But basically, Claire's link to her Twitter feed basically was targeted, and it was attached to strobe lighting, which is obviously very dangerous to somebody who has epilepsy, and it could have effectively endangered his life and obviously put him at risk of seizures. As a result, Zach and Claire are going to talk to us through a Q&A about their campaign to change the law so that they make change the legislation so that we can have much stronger security for people who suffer from epilepsy. So Claire and Zach, can you tell us about your experience on Twitter and how you were targeted with malicious tweets?
Hi, yeah, so originally we set up a Just Giving page to help raise funds for Epilepsy Society, and we were taking part in the Zach was taking part in the 2.6 challenge. So I started mentioning Epilepsy Society on our fundraising page as I was tagging them on Twitter, just to generate a little bit of interest in the case. And then unfortunately, we were made aware by Nicola, who's also here with us today, that we'd been attacked overnight with strobing images, GIFs, toxic messages, awful, horrible things trying to induce somebody with photosensitive epilepsy to have a seizure.
Thanks for that, Claire. And if I could just turn to you, Nicola, how widespread is this problem, and what is the charity doing to address it?
It is unfortunately pretty widespread. In this last year, we've seen a real increase in a coordinated attack on Twitter of people with epilepsy. And it's by, or we call them internet trolls. They're really vile posts which are sent. It's either flashing lights or very geometric patterns. If we could go on to the next slide, I can give you a few examples of some of these. There's just a few examples, and obviously they're not animated, but when these come through, they are all animated. You'll see there's quite geometric patterns, which for somebody with photosensitive epilepsy would endanger them to have a seizure. The very horrible black and white chrome style video would be flashing, so flashing lights, and the seizure, the chromatica, and the pink tweet on the left, they would have all had flashing images. The internet trolls use a lot of videos from some of the big pop divas like Miley Cyrus and Ariana Grande, and yeah, a couple of the others. What they're also doing is they come onto our site and they identify those people who are sharing with others the fact that perhaps they're 11 months seizure free, so another month, and they could be a year seizure free and would be able to apply for their driving license again, which is a really big hurdle for people with epilepsy, because one of the big impacts of epilepsy is that you can't drive with active seizures. So they will come on, they'll identify somebody such as in the top left-hand corner where there's a picture of the dog, and the one of our supporters, Tom, was saying that he'd been seizure-free for some time, and he was really celebrating that because he has uncontrolled seizures. And so they posted a flashing image saying, time to end the streak, babe. And that is very, very typical. And we are so relieved that that they didn't actually affect Zach, that Zach didn't have a seizure on account of these tweets. But in actual fact, several of our supporters did, several of our supporters around the world, including a young man, 25-year-old man who'd been newly diagnosed with epilepsy. And it can be quite a traumatic diagnosis because it is life-changing. And he was advised by friends and family to go have a look on our Twitter feed to get peer support and to get all the right information and advice. And he came onto our Twitter feed in May, which was when this attack really sort of got going. And unfortunately, he was met with flashing images. It caused him to have a tonic-clonic seizure. He bit through his tongue. He was psychologically traumatized by the event, and he's not been back on Twitter since. So not only has he got that horrible experience of having a seizure and the injuries that can result in, but also he's now not able to get the peer support, which social media can be so fantastic for, especially for people with disabilities. So he's not getting that peer support or information. And if we can just go on to if you could just go on to the next photo, I think it is. Yes. So I think that one of the real problems that this is identified is that when you look at this, is just a very small selection of people with epilepsy who've sent in their photographs, again via social media, which shows how fantastic it is, because people are showing photographs of themselves which show that they're just like everybody else. You can't see epilepsy. It's a hidden condition. So prior to the advent of social media, you would have never been able to identify a group of people with epilepsy out on the street. But social media has allowed these people to become a target and to sort of generate the very worst of, I say, the people living on the outside of society, really, to target them and send them seizure-inducing tweets. And I think that what we've had trouble conveying to people is that it's not just a seizure at the time. It's not a seizure. You don't just fall down and then you get up. If you could go on to the next photograph, you'll see just the devastating effect that a seizure can cause. And these are obviously facial injuries, but people break their backs in the course of a seizure. They break their collarbones. They have, because they always fall in the same direction. So it's reoccurring breakages that they tend to have. They break their glasses, their teeth, psychologically traumatized. And sadly, we do know that 1,000 people every year in the UK die of seizures. We thankfully haven't had anybody die of a seizure caused by photosensitive epilepsy, not that we're aware of, but we don't want that to happen.
Thanks very much, Nicola. Zach, can I just turn to you now? How does it feel to have a potential law named after you, and what do your friends at school think about it?
Well, I'm not really been talking about it at school much, but I assume if I did talk about it at school, some pretty shocked.
Pretty shocking, isn't it? It's pretty surprising.
Yeah.
But your family are really proud, aren't they?
Yeah.
Yeah.
Not only that, your solicitor's very proud of you, Zach. And I believe that you've been in touch with your local MP, Claire, Tracy Brabin, about this issue. How supportive has she been?
Yeah, she was great. At the beginning of all this, I tweeted her as well to let her know about what was going on. And I think Nicola also got in touch with her. She phoned us personally to see how we were. She spoke to Zach. She actually donated money to the cause. And then even better, she joined onto our conference call with the Epilepsy Society and the Law Commission when we were discussing Zach's law and trying to get epilepsy included in the online harms bill. So yeah, she's massively behind the campaign for us.
That's great. And just picking up with you, Nicola, that you've been working with the Law Commission, and that's resulted in recommendations that the Communication Act and the Malicious Communication Act will change. Do you think this will result in us getting a change in the law and perpetrators of online harm targeting people with epilepsy being brought to justice?
I think it is a real step in the right direction. I wonder if you could go on to the next slide. Thank you, which talks about Zach's law. So what we have been asking for, which is that this sort of abuse should be recognised as a criminal offence, and the dissemination, the knowing dissemination of this sort of abuse should be recognised within the Online Harms Bill. And we are thrilled. The Law Commission has really listened to what we have been saying. They've really taken on board the horrible nature of this crime, and they've also recognised that the perpetrator of this sort of abuse is actually could be held responsible for actual bodily harm or even grievous bodily harm. So we're really pleased with that. We're really pleased with the recommendations to change the Malicious Communications Act and the Communications Act. However, we don't want to win the fight and die in the ditch, because we know from the nature of a lot of the posts which are sent, they seem to come from abroad. So they're going to be outside of UK jurisdiction. So that is a real concern for us. So we are really pleased that the Law Commission are taking on board what we have said, and their recommendations will go so far. But they recognise as well that there's going to be little they can do. And we're working with the police at the moment, and they say they're investigating quite a few of these internet trolls, but if they get to the border of the UK, then they have to hand it over to another country, and then it's in the lap of the gods what will happen next. So this is why it's also so important for us to press the government to ensure that the Online Harms Bill will compel social media companies to introduce much tougher regulation, and there will be penalties for this type of abuse being allowed on their platforms. So we are working with the Department of Culture, Media and Sport on this, and we've had a lot of meetings with Caroline Dinage. We've been in contact with Oliver Dowd, and Boris Johnson has been on our case with us. As Claire said, we had a really successful breakfast meeting when the Law Commission, DCMS, and we had, thanks to the power of technology that we're using at the moment, that we were able to have people from around the world talking about their experiences of the way that these type of attacks had affected them. So that has been brilliant. But we are also talking to the social media companies individually as well, to try and get them to address the issues from within, because we really believe that they've got the power and the expertise to introduce algorithms that could stop these type of attacks in their tracks. So with Twitter, they've been very responsive. They have set up, we've got virtually a live link with them. So as soon as an attack starts, we are able to contact them and they will intercept as much as they can, but it's still very manual. TikTok, we're pleased to say, have introduced a new feature to their social media platform, which will identify photosensitive content and will alert the user to that and give them the opportunity to opt out. So that is really good. But we do think that the social media platforms could be doing a lot more. And we think that the only way to get them to do more is to hit them where it hurts, and that is financially.
So it sounds like, Nicola, that your charity is actually policing the social media for them and actually keeping people safe. Well,
in actual fact, this is something that we do keep raising with them, because we are a very small team. It's myself and one other, and so we haven't been able to do a lot of our charitable work because we have been policing the social media platforms, and literally since May we have had thousands of these type of tweets sent to us. So, and it's not something we can leave to chance. It has settled down a little more just recently, but we're being very cautious about the sort of material that we post. Anything, even though it's positive material, anything that's going to generate more attacks from internet trolls. So yes, we certainly think that it should not be our responsibility. And the people who raise money for us, like Zach, who has done a fantastic job raising so much money for us, we don't want that money to be spent on policing social media. We want that money to go into research and services for people with epilepsy that will help people like Zach.
Yeah, exactly. And just coming back to you, Claire and Zach, has this experience put you off using social media?
There were a few times when we wanted to back away from it, and Nicola said to us, if we didn't want to keep being involved in it, then we didn't have to. But at the end of the day, that's not how we should treat bullies, is it? We stand up to bullies. We don't sit down and take the abuse, because if we allow that to happen, we're allowing it to happen to the rest of the community of people who are using these platforms. Like I said before, it's for communities to help each other. It's not for them to be attacked. So we have to stay together and stand together and try and fight against these things.
Yeah, absolutely. Just again, well done, Zach, for raising over £20,000. Can you remember exactly how much it was, Zach?
£20,337.
Yeah.
And if
but
anybody,
the page is still open.
Exactly. If anybody wants to sponsor Zach, we'll gladly send on the link. Nicola, just coming back to you. Obviously, this must be a source of absolute anxiety to people who suffer from epilepsy. Do you think it puts people off using social media? You gave the example earlier of the newly diagnosed contact that you had who basically suffered from a fit because he looked at Twitter and he was only trying to get information about his condition. Have you heard of any other examples?
We have, yes. We've had quite a few people saying that they're very cautious now about going onto Twitter. We have, we do, it's almost like singing to the choir, that we do put out messaging on Twitter about how people can safeguard themselves, and we have a chunky section of our website which is dedicated to this. So yes, that is the website address for where we've got YouTube, we've got videos and written information about staying safe. And but yes, it is putting people off, and then that creates isolation, and isolation is a very big thing in epilepsy. So we don't want these internet trolls to win on any level, and we will keep campaigning to make sure that they are driven out.
That's absolutely good to hear. So please remember to add your questions to the Q&A, and I'm now going to hand back to Katie.
Thank you very much to everyone that's just been speaking. That is a truly inspirational team that we've just heard from. So now it's for me to start up the question and answers as we've come to the end of our presentations with our speakers. We have had a lot of questions come in, so thank you very much for those that have posted beforehand and during the event. There are lots of questions, as you can probably imagine, for Jeff. And so I will kick it off. There is a question in advance and a question that's come through during this session about children essentially wanting to create YouTube channels. And the question is, how safe is this? So one for Jeff, please.
Right, so I've sent a private message as well to the lady that asked the question. As I said, what I wouldn't do is stop people using the internet and everything that it can offer. What I would advocate is plan what you want to do on it, think carefully how you're going to do it, and put the measures in place to then be able to do it safely. So, for example, the YouTube channel, absolutely go and create a YouTube channel and use it and enjoy it. And I think it was in relation to a crafting hobby. It's brilliant, go and do it. But perhaps create a new email address, think about the profile you're going to set up on there. Don't link the email address to anything that you might already have online, personally speaking. So like your Facebook account, for example, that you might want to keep private. So yeah, I mean, I'll gladly speak to anybody that wants advice on setting it up. But I would say just step back, don't rush into it, and plan it. You know, think about the photograph you're going to use. How much of you do you want to actually be out there? I'm not saying hide away behind a face mask and pretend to be somebody you're not. Be proud of who you are and what you're doing, especially, you know, at that age and wanting to set up a YouTube channel and crafts and that. Share it, use it to benefit you and others, but just think carefully about how you actually set up the initial account and how you're going to portray yourself online. as I say, simple things like what's behind you, that kind of thing.
Thank you very much for that, Jeff. I hope that answered the question. As a follow-on for Jeff, I think if I ask the questions related to Zoom, what safeguards should be put in place for working with vulnerable children and adults through Zoom? And then a follow-on question is, when our therapists are engaging in Zoom sessions with vulnerable clients, how can we make those as safe as possible? And is there anything that we should all be aware of? So again, I think that's one for Jeff, please.
So again, I don't want to sound vague when I say this, because everybody's different and the systems that you use and the devices that you use are different. So I would say certainly with platforms like Zoom have come on a lot. I know when lockdown first happened and Zoom started to come into the limelight, there was a lot of concern about the security of Zoom and other people being able to access your Zoom meetings and so on. It's come on a lot over the last 9 months. There are other platforms like Teams as well, and they all have very similar security features in there if you use them. So make sure that you set the meeting up securely, check your settings on your device, which again, probably take a bit of time to go through now, but if you have a look at the settings on your profile, when you're logging into Zoom, for example, who's going to be present, what's in the background, that's a biggie. So many people forget the backgrounds and give a bit too much away. Is it going to be recorded? Depending on the subject of the conversation that's going to take place, recording it might not be such a bad thing if you're needing it as part of your, let's say it's going through the court protection process, for example, then the recording might be needed. But obviously make clear that it's being recorded and make sure everybody understands what's being recorded when you're undertaking it. There was another question as well, which, sorry to just sidetrack a bit, there was one I saw about blocking email addresses. Again, it depends on your email provider. So Google, for example, if you've got a Gmail address, you can go onto your Gmail account settings online using your browser and go into the settings there, and you can block specific email addresses if you're having a problem with it. Again, I would say look at your provider and just do a search on Google or YouTube to find out how to block somebody on your particular chosen platform for the email addresses, or the platform for social media as well. Don't forget to block people on social media if they're becoming a pain in the backside. Sorry, Katie, what was the other question?
I think that's followed up on both of the questions. So thank you, Jeff. And just a final question for you at the moment. There's been a question about whether you have a preferred browser to recommend that people use.
Right, so in relation to browsers, you tend to find browsers are specific to devices. So for example, Apple computers, you've got the Safari browser. I wouldn't recommend a particular browser per se. What I would say is look at the browser you've got that's come with the device and explore the settings on it. So many people don't realize what the browser is and what it can do. And you can use a lot of the security features within the browser to manage the safety of those that are going online and using the browser to access the internet. And that's ultimately what a browser is. It's a bit of software on your computer that allows you to access the internet. It's like a user interface, in effect, between us humans and the internet, the digital side of the internet. So you can use it for simple things like storing favorites, bookmarking web pages that you might visit on a regular basis, history management, that kind of thing. So I would say look at the browser that you've got and just do a little bit of research again. Google it or look at the help section on that browser and find the features that are most useful for you.
Thanks very much for that, Jeff. Moving away from Jeff for a moment, we are going to be returning to him as there are other questions for him, but there's a question about whether images of people used on the internet for marketing, fundraising or publicity purposes require capacity assessments. Now, my immediate response to that is yes, you would need permission from that person to use images for their own images for advertising, so they would need to have capacity to understand what that means and to consent to that. I'm going to tag on to Rosie here to give any follow-up comments that she might have as well for that question.
Yeah, I think I would agree with you on that, Katie. In order for you to have images of yourself placed online, then you ought to be able to consent to them being placed online. And that would mean ensuring that a person had capacity to consent.
Lovely, thank you for that, Rosie. A further question for Jeff, if I may. Supposing that your services have been engaged to support a particular client with safe use of the web, and in that training you discover that there has been some criminal activity, and I'm sort of thinking the most likely is pornographic images and paedophilic images on the internet, and those being downloaded. That is of course a criminal offence. What is your company's position, I suppose, on discovering that kind of content?
Good question. So what we always do before or when we engage with clients is we have a discussion around the parameters for our engagement with them, and ultimately safety of individuals and life comes up at the top. We don't go rummaging through and examining devices per se. So if we're handed a device by a client to check on the settings, for example, and we find something that's inappropriate on there that is evidence of an offence, then that is managed with the case management company accordingly, and that would obviously depend on the ages of those that are likely in the images. But we wouldn't overlook criminal offences, but we would support the case managers in that process. But where there's any indication of a police investigation, and we wouldn't get involved in that sense anyway, we wouldn't want to compromise any police investigation if one was being undertaken at that time. There was another question as well, actually. I just noticed, if it's all right to answer this. It's in relation to YouTube videos. We had a client that we did some work on a couple of years ago that wanted to be removed from Google and search engines. And so we went down the painful road of trying to be forgotten online, if you've heard of Google and the right to be forgotten. It has got easier since, and it's a similar process with YouTube. If there are videos on there, then you make representation to YouTube through the contact details that there's. It's tucked away a little bit, but you can find it on the YouTube site where you can contact them and ask for a particular video to be removed. You'd need the URL from that video, which is in the little white box at the top on your computer screens. But there is a process where you can apply for them to be removed, but whether you can actually get them removed, that's another challenge.
Thank you very much for picking that up. A further question for you, Jeff, and a technical one. What safeguards would you recommend putting in place for working with vulnerable people through Facebook Live, WhatsApp and Zoom? And do you have any policy examples that you can share?
Right, yes, I saw this one about the policy examples and so on. Right, first and foremost, it's difficult to give you a blanket policy that will cover everything, because as with any policy, it's got to be bespoke to the circumstances of that individual and what you're aiming to achieve from it. Policies don't have to be complicated, and again, I don't mean to patronise anybody listening when I say this, but people can sometimes overthink and overcomplicate policies, so that they don't have to be difficult and cumbersome. And that ties in with the decision making. We do, strangely enough, or we will be offering some training around decision making very soon online. It'll just be a short online course, but we're finding that decision making and the rationale behind it being tied in with policies is an area that could be developed more in this area. So in relation to Facebook Live, WhatsApp, FaceTime and all the rest of it, it depends depends on the individual and the circumstances and what you want to achieve from either restrictions or security. What are the threats? Once you know what the threats are to that individual and the set of circumstances, then you can make your decisions, put in your working strategy to manage those threats and develop a policy around it, if that makes sense. It's an easier process than it perhaps sounds, but it needs to be done. That's the main point.
Thank you very much, Jeff. I think that brings us to the end of the questions that have been asked. I know that there has been the link to Zach's Just Giving page that has been posted on the public Q&A for any of you that are interested in that. It's now for me to thank everybody for their time in joining us today. If you do have further questions, please do feel free to get in touch with us after this event, and we will do our best to help you directly. My thanks to all the speakers today who have presented and spoken about very interesting topics, and I hope you have all found that as interesting as I have. Just a reminder from me, please to keep in touch with Erwin Mitchell. And please do visit our page, erwinmitchell.com, for all the legal updates that we post on a daily basis as the law changes that quickly, and future webinar details that may be of interest to you. I'd also be most grateful if you could take the time to give your feedback for, I think it's a 2-minute feedback session, which would be very gratefully received. You can see that the final few slides that are being presented just gives you information about our community on Facebook that may also be of interest to you all. So that's it from us. Thank you very much for taking the time to join. I hope you've enjoyed it, and look forward to seeing you hopefully for an event in the future.